everyone, and welcome back to AIADA's AutoTalk. I'm your host, Rachel Soleimani. For our newer listeners, anyone who is registered for today's program will be receiving a copy by the end of this week. And if you have any questions, be sure to enter them in the Q&A bar at the lower right-hand side of your interface. Joining us today is Brad Miller, Chief Compliance and Regulatory Officer, Head of Legal at ComplyAuto. Brad, I know you have a lot of important information to share with us today, so I'll let you take it away.
Well, fantastic. Thank you, Rachel, for having us, and thanks to AIADA for the partnership. We're relatively new to this partnership, but it's been a great one. So looking forward to continuing that, and thanks for the chance to chat with AIADA members today. So we're going to talk today about an issue that's it's an interesting issue. It's a bit of a sleeper issue in the sense that I'm firmly convinced there are a lot of folks that don't understand it at all, and those that do, I think, frankly, don't understand it fully because it's complicated, and B, it's changing. And so we're going to talk a little bit about the current regulatory and legal status of website tracking technologies. It's an important issue. I remember when I first learned about it, I thought it was sort of one of those niche things. But as I've been at ComplyAuto and seen how it's operated in the world, I really think it's something that dealers should be aware of for a variety of reasons. So with that in mind, let's talk a little bit about, let me get the slides going here. So I have to start with a legal disclaimer. I am a lawyer, but I'm not your lawyer, so I'm not giving legal advice. So this is guidance, obviously. We work hard to stay on top of the latest and greatest in this area and many others, but I always have to make sure that I'm very clear that I'm not your lawyer. There's no legal or lawyer-client relationship here. Who am I? My name's Brad Miller. As I said, I'm with a company called ComplyAuto. I was 16 plus years, I was at NADA. So I was a lawyer at NADA for a long time. I was in private practice before that for a number of years in DC. As a litigator and as a regulatory lawyer. And I was chief regulatory counsel at NADA, working on behalf of franchise dealers for a long, long time. So dealer advocacy is really sort of in my blood. It's been what I've spent my career doing. And about a year ago, a little less than a year ago, I joined ComplyAuto, which is and ComplyAuto is a software company that really does a nice job in a variety of spaces with auto dealers. Auto dealers are our clients, franchise dealers, independent dealers, but mostly franchise dealers, and specifically in the areas of privacy and data security, safety, F&I compliance, advertising compliance. Dealers, as I'm sure you're painfully aware, are among the most highly regulated businesses, certainly small businesses in this country. So we have a suite of software products that really help dealers with all those issues. Okay, so today we're going to talk about the website tracking technologies. It's sort of a complicated issue. I have to start by saying I have a lot of slides, but I did that intentionally. I want you to sort of have these slides as a resource. We have resources on our website if you want to learn more, and longer webinars on and more specific issues. But I want to give you an overview of the issue and give you some resources to go back to later, because I think it is something that's important. So we're going to talk about what they are, why it's important for you to understand what it is, and then obviously some strategies and ways to get control over what's happening on your website and to hopefully reduce the litigation risks here. So at 50,000 feet, what we're talking about are websites, right? I mean, I don't need to tell you that dealer websites are not just passive advertisements anymore. Even your VDPs, your inventory listing, your hours of operation, all the things that traditionally happened on websites. It's really because of online commerce and digital retailing and how much more of the online process happens on the website. It's become much more of a massive data collection source. And that has implications that dealers, I think, still need to get their head around, right? I mean, you're taking credit applications, you have chat bots that go through the whole sales process. People are sharing all sorts of information, and a lot of it's non-public personal information. A lot of it's very sensitive financial information on your website, right? And on top of that, on top of what's happening on the surface in terms of sharing between you and your customer, all monitored websites, including those that dealers use, and dealers are frankly at the forefront of this in many ways, will employ a litany of tracking and other technologies. So you've got cookies, you've got pixels, you've got scripts, you've got all these things that are running on your in the back end of your website. And the idea there, as you can see, is to improve the shopping experience, right? If you know that I've been on your site looking at these types of things, you can remember preferences. I can pick up my shopping experience where I left off, and you can track me and give me and follow me across websites. That's called retargeting or repurposing, right? So there's sort of two features. One is following what I'm doing while I'm on your website, right? So Brad Miller was on your website for this long, looking at these type of things, interacting in the following ways, and then you're also able through some of these tracking technologies to then follow me across websites. So you can serve me up an ad for Silverado that I was looking at if I'm on another website, right? You know kind of how this works in modern commerce, but there's a lot of different functionality that happens, and that's obviously not as transparent to the consumer, and that's where some of the legal issues have arisen in the back end of those applying those tracking technologies on the websites. So as you know, see the last bullet there, they proliferated. There are these are have exploded in the last few years, and I have to start by saying many dealers are massively on top of this. They've got whole departments of people that are looking at this from a marketing perspective, but there's another side of it, which is the legal side of it, which has kind of raised its head in the last few years that has created some issues. So there are concerns and risks that dealers really have to understand. So that's what we're talking about, right? So what does this mean? This means that you've got all sorts of sensitive data you're collecting, right? So that raises obvious compliance risks for you as a company. It also raises obvious business issues, right? I mean, 15 years in NADA, I fought a lot of battles over dealer data, dealer sharing with the DMS companies or CRM companies or your OEM that wanted to share and extract all this information from your DMS. To me, this is sort of the more modern equivalent of that battle in the sense that all this information now exists on the websites. And the question is, who is accessing it and for what purposes? And do you know this as a dealer, right? So you need to know what's going on. These are your leads. These are your customers. This is your inventory. You need to understand. And when people are on your site getting access to information about your leads or your inventory or your customers, you should know that, right? And there should be strict contractual controls over who's accessing it and for what purpose. Okay, so that's just the business side of things. On top of that, we're going to spend most of the time today focusing on the legal side, which is in large part tied to this massive increase in litigation over what's called cookie tracking technologies. And there have also been some attendant regulatory actions that are also at the same time. We'll cover that very quickly, but suffice it to say, this has become a very, very hot area of the law. There are a number of law firms that specialize in sort of sending hundreds of demand letters against businesses of all kinds, including dealers. And we know of a lot of folks in the auto space that have gotten these demand letters. So you need to understand what's going on and protect yourself before those lawsuits come. And then you have to know the practical implications, right? We're going to talk about that very briefly. But the reality is, when you follow the rules and you protect yourself from a liability perspective, it can have implications in terms of the scope of the data that you're able to obtain, especially analytics data. And there are some business implications, and you have to understand what the trade-offs are, and you got to make the right decision for your own business. And then, of course, you have to have the tools that can be customized in a way to make it work for you. Okay, so that's a very, very brief overview of a very complicated area. So I'm going to go through the rest of this relatively quickly, but again, most of this is so you have a copy of this later you can look at. Obviously, you can reach out to me with questions or ComplyAuto with questions if you have any. But what are we talking about, right? Everyone has heard these terms, cookies and scripts and chat bots and the rest of these things. Remember that cookie is literally just a little file. It's at least a little piece of code that is set by a website or the server, and it's stored on my computer. So I'm Brad Miller. I'm shopping at millermotors.com on your website. And in the action of me interacting with your website, a text file is set by the website or the server on my computer, right? So it's a cookie on my computer. The idea is you now know that this computer is tied. You don't necessarily know my name at this point in time. You may know my IP address, but you set that on my computer, and then depending on the functionality of it, you can track what I'm doing, as I said, on your website or across websites, right? So it's used to remember information, right? It's literally a pixel. It's literally a very tiny little pixel, like one little piece of code. But there's a lot of different things it can do, right? So again, you don't need to know exactly the technological side of things. What you need to understand is what's happened is I'm Brad Miller. I came to your website, and as between that interaction, something happened on my computer that I may not even know about, right? And that's kind of what's creating the issues here. So again, there's other things. There's pixels and web beacons. You look at this at your own leisure. But pixels. Well-known examples here are Metapixel and Google Ads. Right. This is where 99% of the not 99, maybe 90% of the issues have come up in these litigation. They generally will cite things like Metapixel and Google Ads as one of the issues in these lawsuits. So again, this is not a niche issue. This is something that almost every website in the country generally has. Scripts, you can take a look at this. They're a little bit different, but they enable interactivity and some functionality. And again, fingerprinting, chat modules, session replay. Geolocation is an interesting one. I'll just highlight only because there are tools and scripts that collect. The idea, obviously, is to get your location, right? They want to know where you are. I'm noting that one in particular because of the fact that the FTC enforcement over this area in particular has increased in the last just few months. You can see this is just from these are all sort of in the last 6 to 12 months, these FTC actions that they brought. And basically what's happened is the FTC has taken the position, whether it's sustainable or not under the current law. But they've taken the position that geolocation data, if it's precise geolocation data, is sensitive, and that when they call something sensitive, that means it deserves sort of a higher level of protection. So if you're, you can see here they brought some actions against companies that collect this stuff without telling people they're doing it and then selling it to people. So you get the idea here. Be careful about this, and this does happen at the dealership level, right? You probably know you might probably have vendors that will sell you a product or service that will purport to say they know where somebody lives and can detect their address or know where they've been. Just keep in mind it's raised a little bit higher in terms of risks for dealerships in terms of geolocation data. But those are all sort of a sampling of the types of technologies. You also need to know a little bit about the difference between first party and third party cookies. So that means basically was the cookie set by you, by Miller Motors? In other words, the domain, and I'm going to use Miller Motors as just a dealer website, right? Was it set as a Miller Motors cookie, or was it set by some third party on the Miller Motors site? And that makes a difference because really it's an indication about whether that information is being shared with another third party. And as you'll see in a minute, that has legal implications. So read this at your leisure. And obviously, there's essential cookies. There are some cookies that need to fire. These are not all for tracking, right? There are some that are called analytics, which is measuring on the website. There are some that are called targeting or retargeting, which tracks you across websites. But then there's also essential websites that just make the website work, right? You can't see the inventory if you don't let this cookie fire, right? So there's some that are just gonna fire no matter what, and there aren't legally an issue necessarily because they're not tracking, they're not doing something in terms of the communication between me and the website. Okay, so take a look at those, and the big idea here is the non-essential, which is the analytics and targeting. Those are the ones at the bottom. Those are the ones that regulators really have focused on. Those are the ones that the lawsuits have focused on. Those are the ones that have the most commercial value, right? You need to know the analytics on your website. There's value in being able to give someone a targeted ad if they've consented to do so. So that's again a very brief overview. Functional and marketing cookies. This is kind of just more detail on what I just talked about. Again, look at this at your leisure. But this is all just to give you a sort of an idea of what we're talking about, right? And it gets complicated, right? There's who's setting the cookie, what's the purpose of it, what is it doing? Is it essential, functional, analytics, or targeting? What is it being shared with a third party? Has it been set by a third party? It can be complicated. Okay, so but the idea here is that all of these have legal implications for you. Okay, and what are the legal implications, right? So I said this earlier, but basically the issue is this: that there have been a number of lawsuits and regulatory actions, but I'm going to focus on the lawsuits that have been brought against entities of all kinds over the last few years, and it's really exploded. And it's become easy because, frankly, it's easy to determine whether whether you've met the threshold requirements that we're going to talk about in a minute. In other words, anybody can go to your website and figure this out. That's the bad news. And the other bad news is if you don't know what's going on with your website, you're probably doing it wrong. And it's going to be easy for someone to send you a demand letter demanding a bunch of money, and you're going to have to make a decision whether you settle these cases or not. Now, most of these do get settled out for reasons we can discuss, but basically, you've got issues with state or with private lawsuits, right? And I will tell you that little parenthetical is important because what I've seen, following this for the last few years, I've seen a marked increase in the last few months in sort of the next phase of the plaintiff's bar approach, which is to assert class action status in these claims. Right. We'll talk about that a little bit. Now, obviously, someone suing you for statutory damages on an individual basis is a pain and it's expensive and it can be bad. But a class action is it's a much different situation because, of course, that just makes the calculus in terms of what liability and what risk you have here much different. Right. So there are federal lawsuits. There are also implications under state privacy laws. And then UDAP stands for unfair deceptive acts or practices. So there's both federal and state enforcement actions that have been brought in this area as well. And I'll cover those as quickly as we can. But again, I don't want to focus you on too much. I'm kind of telling you this because if it is very confusing, frankly, and even most lawyers don't fully get the fact that it's not just state privacy laws we're talking about, right? If you're in California, immediately they think, oh, you have to do these things because of the CCPA or some other state. That's part of it, but it's actually a small part of it. And again, there's a whole bunch of legal theories. Again, I'm not going to go through this. We could go through this if we had time, but it's not just the state privacy law, right? You got wiretapping statutes. You got these common law claims like invasion of privacy, common law fraud, trespass to chattels, even. So this is like sort of pointy-headed lawyer stuff. But I just want to I want to kind of give you a sense of how complicated this can be. So, what are the private lawsuits? This again, this you can't read this now, but this is just an example of a real life demand letter that was received by a dealer, and this is where most of the lawsuits have come from, and believe it or not, the legal theory is basically this: that there are these existing statutes under state and federal law that prohibit wiretapping. So literally, the statutes that were passed in whatever it was, this early 70s, that made it illegal to tap into a phone line and listen to a conversation between two other people, right? The plaintiff's bar has looked at those, and under the terms of some of these statutes, it's broad enough to assert the following: that by planting these cookies and tracking technologies on the website, especially when a third party does it, especially for the purposes of marketing, that you have engaged in wiretapping because you've intercepted a communication between Brad Miller and Miller Motors, right? I went onto the website, gave you all my information. I meant to give it to the dealership. I didn't know, this is the theory, that there was a third party listening into this conversation and getting all this information about me, right? So that's basically the theory. And they say, therefore, by the way, under the California statute, the SIPA statute, which you see here, there's actually statutory damages of $5,000 per incident. So they say, oh, I visited your website 7 times, $5,000 each. That's 35 grand. Pay me, or whatever it is. You can say here, pay me $60,000, right? And they send these things out by the hundreds, and then they give these little screenshots of your website showing that you did these things, right? And this is one of the main state statutes, but it's not the only one. And it's called SIPA. It's a California statute. And of course, you can see there $5,000 statutory damages and a private right of action. There's a lot more details here, but suffice it to say that there are other states. There's a Pennsylvania version of this that has found some success in the courts. There's some other state versions of this. But even if it's just the California statute, they're filing hundreds and hundreds of these lawsuits against businesses all over the country. So my message to you is don't sit on this if you're not in California. If you're in California, you're probably in the highest risk jurisdiction. But even dealers in other states have been at the receiving end of many of these lawsuits and demand letters. They've had a particular focus on automotives. We've had dealer groups, we've had OEMs, dealer website providers, inventory websites, even captive finance companies and manufacturers themselves have all been on the receiving end of these lawsuits. And again, I'm not going to go through the claims again, but I just want you to sort of basically understand what the gravamen of the complaint is, and it's not just limited to California. I mean, here's an example. It was a dealership in New Jersey got a class action notice from California residents about a chat module, right? So you look at this when you can, but it is not happening just in California. Now, you've not heard a lot about this because, frankly, I think most of these are settling out, right? So they don't make it into the courts, they don't make it into reported cases, but they're happening by the hundreds, I can tell you. So again, there are more theories. You can look at this when you get a chance. There are federal wiretapping statutes. As I said, there's UDAP and some other things, and state privacy laws as well. But again, not just California. Here's a Third Circuit case from a few years ago in Pennsylvania, which is why one of the reasons we call Pennsylvania sort of a higher risk jurisdiction today. Now, I will, on some good news, there was a recent case in Massachusetts. Massachusetts, we used to call a high risk jurisdiction, but there was the highest court in Massachusetts recently sort of declined to extend the wiretap law, the Massachusetts version of the wiretap law, against a hospital. Now, I would argue there's some facts in that case that made it particularly difficult for the plaintiffs. But yeah, hopefully you get the message. This is not just a California problem; it's all over the country. Again, here's the Federal Wiretap Act. You can look at this when you can. There is a federal claim that is brought in some of these cases. Same concept. It's sort of, have you gotten consent from both parties to listen into this communication, or you've intercepted it under federal law. Okay, I touched on this, but I'll just briefly mention it. A recent really marked growth in class actions, right? As I said, today most claims have been individual, that now they're really bringing class action claims. And I'm going to tell you what they've basically done, and it has to do with the banner that I'm talking about in a minute. But what they basically now are saying is, okay, the wiretapping is one thing, we've done that, but on top of this, the steps you're taking, whether it's a cookie banner or your privacy policy, actually what you say you do in those things is not actually happening. Therefore, what you're telling me is deceptive. And the reason that's good for a plaintiff's lawyer is because if you're under SIPA and you want those statutory claims, to get a class action, you got to do all sorts of legal hurdles to certify a class to show that the people were impacted in the same way. With a UDAP claim, you don't have to show that. You just have to say it's deceptive. It's deceptive to everybody. Therefore, I'm filing a class action. So that is a big change. And to me, even if you looked at this 6 months ago, it's something worth looking at again, because I think the calculus has changed, because it just has become more risky in this area because of the class action that are finding some success in some states. Okay, just as another piece of this, for those of you, this is just one example. This is in New York. You can see this, but the AG's office, this is happening in numerous AGs around the country, but this one was specifically on target, so I wanted to share it with you. You can see this mid last year, New York AG came out with a whole guide on this exact issue, right? They have a consumer guide and a business guide, and they basically said, hey, it violates our state consumer protection statute if you don't get consent before you start loading these cookies from people in New York. And they went to a whole bunch of websites and showed how it didn't happen. It explains what cookies are, explains what banners are. And you can see here, there's a link when you get these slides. You can take a look at this if you want. I mean, we were very encouraged by this in the sense that it was consistent with what we've been saying for several years in terms of the categorization of the cookies, how to block them, and we'll talk about some of those details. But I do want you to know it's more than just these private lawsuits. Many AGs have signaled, and there have been some enforcement actions saying, look, it violates our consumer protection laws in our state for you to be implementing these cookies and other technologies without getting consent from the consumer first. And you have to get consent in the right way, right? I mean, the little examples of these banners you see on the right here are basically ones that they say are good or not good, right? There's things called dark patterns, where they claim if you don't get, it's not just getting consent, you have to get consent in the right way, or they basically say it's not valid consent. So it has to be non-misleading. The interface has to be easy to use, the same colors, everything else. So again, what does this mean? There's no state privacy law in New York yet, but they've signaled that they're still going to be bringing enforcement actions under this. You can see here that it basically says if you don't get consent, it violates the New York consumer protection laws. Okay, so look at that when you can. So again, that's not just New York; it's just an example, but I think one of the most on-point examples recently. In addition, the FTC has brought enforcement actions at the federal level. So look at this when you can. But again, the idea is the same. If you don't get consent before obtaining this information, certainly if you go on to sell it or use it for retargeting, they found that to be a violation of Section 5 of the FTC Act and brought enforcement actions against companies related to that. I do note here, it's interesting to me, Facebook or Meta just recently announced a change. If you look at the terms and conditions of Facebook, which only someone like me who obviously needs a life would look at, but they recently just changed this to basically put the onus on third parties not to share certain kinds of healthcare data, and I think that was in reaction to what the FTC has done. So this is making its way through the ecosystem slowly. Again, I'm going to run out of time here soon, and I'm going to go very quickly just to wrap this up. But on top of this, you've got state law implications. There are now 19 states that have state privacy laws. Almost all of them address retargeting. You have to do certain things. You have to have an opt-out separate from your cookie banner. You have to. It's prohibiting the sale of it. You have to have certain contract amendments with your vendors. A lot of complicated things you need to do under these state privacy laws related to cookies and other data. And this is a bit of bearing the lead a little bit here, but this was just about a week ago, or week and a half, or actually it was a couple weeks ago now. But the first time the California, you may have known that California has the California Consumer Privacy Act, CCPA. They have an agency that they set up called the CPPA to enforce the privacy law. First time they brought enforcement action. First time they brought it against Honda Motor Company, and it was related to their non-compliant cookie banner. So they had a banner, they just didn't do it right. And as you can see, they had to pay a $600,000+ fine to the state of California and do all sorts of other things to comply with the settlement with the state. So I find it noteworthy that the CCPA applies to all businesses of all stripes. The first one that they brought was against an auto specific website. So again, take a look at that. That you can see this it's from our website. We did a story on this if you want more details. But that's obviously big news. So again, I'm not going to go through this. This is under the state law information. I want you to take a look at this when you can. But keep in mind that Google Ads and Metapixel are basically examples of targeted advertising and other and tools that are regulated by these state laws. I won't have time to go into this, but look at this when you can. This is another issue that comes up under state laws. You have to honor these global privacy control notices. Okay, so the risk of going over, what does this all mean? Okay, you've got to have a banner on your website, and it has to be a banner that actually works and says the right things, right? You may have seen these banners, and you probably say, "Why am I seeing all these banners on websites all of a sudden?" Well, this is why, right? And I can tell you that having it is not enough, as Honda learned, right? You have to have one that actually prevents the cookies from firing until the person gives consent. That's the key, right? It also needs to tie into a privacy policy that's compliant both federally and under state law. That's complicated, but you need to do that, right? And there's some other things you need to do. I talked about dark patterns. You can't have a banner that has a dark pattern on it. Like I said, Honda had a banner, had a consent that they claimed to get, but they still got hammered by the California agency because it was misleading in the way it was done. So this can be very complicated, right? But you have to have a banner on your website. Again, this is not the ComplyAuto one. Ours looks different than this. But the point is, it has to have the right language. It has to link to a privacy policy that's compliant under state law. And ideally, if you're in a state that has privacy laws, it has to tie into the back end that allows consumers to exercise their rights under the state law. So I've hit you with a lot of complicated stuff there, but trust me that it's not just a matter of just getting some low-cost solution, just slaps up some language and doesn't do anything. That puts you in a worse position than if you don't have anything. Because as I said, that's where the class actions are coming from. People put these banners up, they don't work. Then all of a sudden you've traded a wiretapping claim from an individual for a class action for deceptive acts or practices under state law. Okay, so all the rest of this stuff, again, I'm not going to have time to go through this. Look at this when you can. But remember, there are a lot of people that want this information, including you as a dealer, right? You want to know what's happening on your website. If you put up a banner, I want to be clear about this. I would urge you as a lawyer, I'm not giving you legal advice, but I would look at these issues to protect yourself from liability. You need a banner that works. If you have a banner that works properly, you are going to see a number of people that opt out, right? There are people that say, no, thank you. Because what you're doing is saying, hey, Brad Miller, before we load any cookies, do you consent or do you not consent? And there'll be about 30% of the people that say, no, thank you, right? So you will have, and again, these are third-party numbers. This is not what we see in our system. In our system, it's a little different, but it's you will see a reduction, right? And so what does that mean? That means you may see a lower percent of your overall analytics data. Uh, there are lots of arguments about what the implications are of that from a business perspective, but you really do need to understand it. And you need to understand that there are marketing companies and OEMs and other folks out there, frankly, that are getting this data from you, whether you realize it or not. And if you implement a cookie banner that actually works, we've actually heard more from third parties than from dealers when we start implementing these banners, because they're like, well, where's all this data we used to get from the dealer website? And my question, of course, is, does the dealer even know this is happening? So again, review your contracts with your OEM, with your third parties, all of them, to understand what cookies are on your site and what they're collecting and what they're doing with that information. That's the bottom line on this. Are you balancing what you may be losing in terms of cookies and analytics with protecting your dealership from liability? Think about it, and just, again, I'm not saying that there's a right or wrong here. People do this different ways, but make sure you're doing what's right for your dealership. Again, you've got to know what's going on your website. We're going to have a video. I was going to play you a video if we had time, but we have a video that's really nice that kind of shows you in 2 minutes how easy it is to see all the cookies that are firing on your website. If it's easy for you to see, it's easy for a plaintiff's lawyer to see, right? And so you got to get this right, because you're sort of dangling out there with a big target on your back until you get it right. So again, I've covered something that's way complicated in a very short period of time. I would encourage you to look at our website for more. Look, ComplyAuto, we have a whole suite of products that obviously address this. We have a cookie banner. Obviously, we work very hard to make sure it's right, that it ties to the privacy policy, that it ties to the DSAR portal and the state privacy laws. But if you don't use us, find somebody else that's compliant. I don't, it's going to be it's complicated to do, and there aren't very many of them, if any. But whether you work with us or somebody else, you got to address this. So I hope that's been helpful to you. It's a complicated issue, and I feel like I've hit you with a ton of information. Your head may be spinning, but take a look at those slides when you can. You can feel free to reach out to us if you have questions. We have lots more resources on our website at ComplyAuto.com if you ever have any questions about this as well. So again, it's an important issue, and I feel very strongly as a dealer advocate that dealers have to get on top of this, but not just for the legal liability piece, but because this is a key business issue for dealers. You need your analytics, but you need to be protected. You need to know who's on your website. You need to know what information they're gathering about your customers and what they're doing with it. So I'd encourage you to spend some time at least thinking about it, and making it a priority to your store. And obviously, reach out to us if you have any questions. So I hope this has been helpful. I don't know, Rachel, if there's any questions.
We do not have any questions come in, Brad, but to everyone on the line, like Brad said, this is a great resource to have. We will be sending it out. You will get a copy of this presentation as well as the slide deck to download by the end of this week.
Well, fantastic. Thank you so much, Rachel, and thanks to everybody for listening. Again, reach out. I know. I feel like with a ton of complicated stuff, it is complicated, but we can help you walk through it if you need some help. But get some help from somebody. I encourage you to, because I think it's an important issue for dealers for a variety of reasons. So thanks again for your time, and good luck.
Thank you, Brad. And to those on the line, join us back here Tuesday, April 22nd at 2 p.m. Eastern as Kerrigan Advisors asks, will 2025 be another record year for dealership buy-sells? So be on the lookout for promotions. For more information about AIADA, visit AIADA.org. Have a great day, everyone.